Can I have confirmation that that started, please? Thank you very much. In which case, good morning. I'm Olivia Parfitt and I'll be the facilitator and clerk for this subcommittee meeting, and I'm pleased to welcome you to this remote meeting of the subcommittee. The public proceedings of the meeting will be broadcast live and recorded for playback on the Maidstone Borough Council website, and members are reminded that the instant messaging facility should only be used to indicate their wish to speak. And from this, we will now move to item 1, apologies. There are no apologies this morning. Item 2, substitute members. We do not have any substitute members this morning. Item 3, election of the chairman. Can I have a nomination for the chair, please?
Nominate Councillor Patrick Garton.
And I'll second that.
Thank you. As we've received a nomination and we have a seconder for that, Councillor Patrick Garton, you've now been elected as chairman for the duration of this meeting.
Thank you, and good morning to everybody. As a chairman, I will ask if there are any disclosures by members and officers. Please speak to make a disclosure only. I can't hear anybody. The facilitator will now ask members of the subcommittee in alphabetical order if they have any disclosures of lobbying. They must answer either none or yes and specify the agenda item or items.
Thank you, Chairman. Councillor Brindle.
None.
Councillor Garson.
None.
Councillor Joy.
None.
Thank you, Chairman. That concludes the lobbying.
I intend to take item 7, application to vary a club premises certificate under Licensing Act 2003 for Marden Cricket and Hockey Club, Maidstone Road, Marden, in Kent, postcode TN129AG, in public. Following the hearing's closure, the subcommittee will retire to private session to consider the application. The decision will then be announced in public again. Item 7. Application to vary a club premises certificate under the Licensing Act 2003 for the Marden Cricket and Hockey Club, Maidstone Road, Marden, Kent, TN129AG. I will now ask that all persons participating in this morning's hearing identify themselves, and starting with the members of the subcommittee. I am Patrick Garton. I'm ward member for North Downs Ward. Been a councillor since 2016, and I chair this meeting this morning. Councillor Brindle, please.
Good morning. I'm Councillor Anne Brindle, and I'm the ward member for Boxley, and I'm a member of the Licensing Committee.
Councillor Joy.
Denise Joy, member for High Street Ward.
Thank you. And our legal advisor, please.
Thank you, Chair. I'm Robin Harris, and I'm the team leader of the contentious team in legal services at the council, and I'm the legal advisor to this committee.
Mr. Harris, your connection, your sound is rather chopped up. You don't have video on at the moment, so I hope that this will not be a problem further on. Can you hear us clearly?
Thank you, Chair. I can hear you clearly. I don't know if that's any better.
It's slightly better. Thank you. Then we have a committee clerk and facilitator. Ms. Parfitt.
Good morning. Yes, I'm Olivia Parfitt and I'll be the clerk and facilitator for this morning's meeting.
Can we now introduce the applicant and any representative for the Marden Cricket Club? I believe it's Mrs. Hayes, the club secretary.
Yeah. Hi, my name's Jo Hayes and I'm the club secretary for the Marden Cricket and Hockey Club.
And then we have Charlotte Hope as well, I believe.
Yes, I'm currently the vice chair of Marden Cricket and Hockey Club and the membership secretary, and I was also the applicant for the existing licence that we applied for 2 years ago.
Thank you. And are there any interested parties? I believe there are none. I can't see anybody on my screen. Can I confirm that the decision to proceed that the decision to proceed in absence of any other objectors is agreed?
Agreed.
Agreed.
Can I ask all parties to confirm that they have received a copy and are aware of the subcommittee hearing procedure?
Yes,
Yes.
I can confirm that.
Councillor Joy received.
Yeah, I see some nodding on the screen as well. I will now explain that the subcommittee will allow all parties to put their case fully and make submissions to the panel within a reasonable time frame. The procedure would take the form of a discussion led by the subcommittee, which with cross-examination usually permitted within a reasonable time frame. Any persons in attendance behaving in a disruptive manner may be directed to leave the meeting, including temporarily, after which such person may submit to the subcommittee over the instant messaging facility any information which that person would have been entitled to give orally had the person not been requested and required to leave the meeting. If this is not possible, they may be allowed to speak at the chairman's invitation. I hope that we are all well behaved this morning. I will now ask that all subcommittee members confirm that they have pre-read all the papers and other documentations regarding to the hearing. For myself, I can confirm that. Councillor Joy?
I have, thank you.
Yeah, so have I, thank you.
Wonderful. So we're all on the same hymn sheet, so to say. Have any draft conditions been agreed between the applicant and other parties for the subcommittee to consider? I assume the answer will be no. I haven't seen anything in my bundle. I will now ask the applicant's request to have any witnesses give evidence at the hearing. So, please, Mrs. Haynes and Mrs. Hope. Who wants to go first?
Is this where I just say our bit at the beginning? Is that?
Yeah, that's basically introduce your application.
Yeah. So that's going to be me. Yeah.
Go on then.
Okay. So we moved into the current site of the sports club in 2018. At the time, we applied for a licence that we thought was going to meet our requirements. But over the last 2 years, we've obviously grown into our site, and we've also grown our membership quite dramatically. So we've now got over 350 junior and 150 senior hockey players, and the growth in the cricket section and the tennis section has been sort of similar proportionately. We've also got a thriving supporter section. So obviously that growth is a positive sign, and it's what we're aiming for. But it has also led us to realise that our licence really isn't fit for what we need it for at the moment. The primary purpose of the club is to provide sport. Most of the events that we hold in the clubhouse and on site are sport related, such as end of season dinners and that sort of thing. We also hold charity events, such as we have a Saints v Sinners cricket match. And this summer we also held Sports Fest, which is a fundraiser for the NHS. Some of the objectors have claimed that we're aiming to hold regular party bookings, and that's not the case. We just want the licence to be suitable for the sporting events that we're putting on. We do aim at the hockey and cricket club to keep our subs as low as possible so that it's affordable for everybody. But this also means that we have to make up the shortfall in our expenses by hiring out pitches and hiring out the club room and such like. I don't think this is particularly unusual for sports clubs, and I think that the growth in our membership is sort of testament to how affordable we're making it for everybody to come and play hockey, cricket or tennis. We currently hire our club room out for some sort of low-key events such as the Wealder Kent ploughing match have meetings with us, the young farmers have meetings with us, and that sort of thing. But they aren't party events. They're definitely sort of low-key bookings. So since we applied for our last licence, we just found that the hours that we applied for were quite restrictive. So we have kids turning up at 9 o'clock on a Sunday morning to play hockey, but they can't go into the club room until 11 o'clock. So parents can't get coffees, and if it's tipping with rain, they can't shelter and that sort of thing. So the arrangement that we've currently got just isn't conducive to the sport that's going on these days. One change that we have applied for is for films. We'd just like to be able to have it in our repertoire for raising extra funds. So much like you'd have a quiz night, we think that occasionally we could hold a film night, and we're not sort of turning into a cinema as it's been suggested. We still believe that the requested changes meet the licensing objectives. We have had the objections listed under the categories of licensing objectives. So if I just look at the public nuisance, Fiona Kitchen, Duncan Shadbolt, Heidi Scott, Teresa Gibson, Mark Walker, Karen Lomas and Mary Bartram all object on the grounds of public nuisance. But we think that they all believe that we're asking for later opening times, and we're not. All of the extending times are earlier in the day. It's taking it from 11 a.m. to 8 a.m. So I assume that the public nuisance part of it won't be considered because it's factually incorrect. Crime and disorder, similarly, we can't see how opening at 8 a.m. rather than 11 a.m. will lead to any increase in drink driving. So people tend not to start drinking at 8 a.m. any more than they do at 11 a.m. So we feel that in that respect, the application's been misunderstood by some of the objectors. And public safety, and we keep coming back to this footpath issue. And this was raised at the last application, or the first application we made at this site. There is a footpath. They keep saying there's no footpath, but there is a footpath, and it does get used. It's slightly longer than possibly the one that some people would want to use, but it does exist. So we don't feel that opening at 8 a.m. will make any difference to people walking or staggering down the road, any more than it would have, under our existing terms. So in summary, we don't feel that this compromises any of the licensing objectives. We have no intention of becoming a nightclub, a film or entertainment venue. We do need to be able to support the activities of the club, and we do need to be able to raise extra funds. We have no public funding. It's all based on subscriptions and activities. So and our sort of success in increasing our membership has led us to this point where we need to extend our licence. So hopefully the licensing committee will see fit to enable us to do that, so we can carry on providing all of the support for all of our members. So, oh, I can't hear you.
You're on mute, I think, Patrick.
Yeah, I can't hear you.
Sorry, I muted myself. I seem to have slipped up a little bit because I should have let our legal advisor go first, but I think we can cope with that. Mr. Harris, if you can quickly summarise the application first, please.
Thank you, Mr. Chairman. Yes, just to be clear, the specific order of the meeting isn't hugely important as long as all the things that have to happen in the meeting do happen in the meeting. So the fact that we've taken the witnessed evidence out of order is not particularly a drama, and in fact makes my introduction very simple. So as you've already heard, the applicant is the Marden Cricket and Hockey Club. they have applied for a variation of their licence in the terms that have already been described and appear on page 1 of the agenda papers. There were no objections to that application for variation made by responsible authorities, the police, for example. However, there were a number of objections made from other persons, particularly local residents. The short details of who those people were and the nature of their objections under the licensing objectives are detailed on page 4 of the agenda. I would mention a couple of other things. Firstly, that there has actually been quite a lot of correspondence between the licensing authority, the applicant and the various objectors, and so the information that appears on page 1 is perhaps a little bit out of date. It might be helpful if the applicant explains when they come on to do their own introduction of their application, the slight changes in the timings that were proposed and discussed and what is actually on the table today. And the final thing I'll mention, just to pick up on a point that was made by the witness speaking, was that she said that what was proposed didn't compromise the licensing objectives. And of course, in actual fact, the test that the licensing subcommittee is looking for is that the application promotes the licensing objectives. It is a positive duty rather than a negative one, if I can put it in those terms. Otherwise, unless there's anything I can assist the subcommittee with at this time, that would be my introduction.
Mr. Harris, you just said the table on page 1 is a bit out of date now. So what is the latest state of this application then? Or do we have an amendment to page 1? I saw several similar tables further down in the paperwork.
So there are various emails that appear later in the agenda papers whereby suggestions were put forwards and backwards and not necessarily accepted. So the application as made appears on page 1. I think what would probably be helpful, bearing in mind we'll hear the application put forward, or the introduction of the application by the applicant, is I think the next step in the proceedings. It'd be helpful for them to be clear what they're actually asking the subcommittee to determine today.
Okay, just one question, Mr. Harris. Opening hours, is that actually for us to decide, or could the applicant set their opening hours regardless of what this committee feels?
So opening hours are advised to the committee, but it is something of a curiosity because opening hours of themselves are not a licensable activity. And so, for example, a licensing activity is the sale of alcohol. So the committee can determine the hours for the sale of alcohol, but ultimately it is a matter for the applicant to determine what their opening hours are, and they are provided to the subcommittee for information. Sometimes, of course, a subcommittee where the opening hours are specifically attached to a licensable activity may change the licensable activity. It may therefore also then suggest that the opening hours should be the same as the licensable activity, because, for example, the Section 182 guidance indicates that, for example, the terminal hour should normally be, for example, the same as the terminal hour for the sale of alcohol. So the subcommittee does have a power to adjust them where it attaches to a licensable activity specifically, and they are changing the licensable activity. But of themselves, opening hours are a matter for the applicant. The other thing that I would mention in respect of the opening hours, because it was raised by at least one of the objectors quite strongly, is that I understand, although I'm not familiar with the planning conditions for this particular site, that the licensing opening hours that are proposed are outside of the hours which is allowed by planning. Again, that of itself isn't actually a licensing issue, because it's perfectly possible to have a license on a premises that has no planning consent whatsoever. And so the licensing subcommittee should not be confused by the fact that planning conditions are different, but it might be something, of course, that the applicant likes to address when they come forward with the reasons why they're asking for different hours on the license than they have on their planning.
Just to, did I understand you correctly? So, because Ms. Hope earlier said we can't sell any coffee before 11. So, if the applicant would go ahead, change their opening hours to whatever, 8 o'clock, 7 o'clock in the morning, and start selling coffee, they could do that without coming to this committee.
Strictly speaking, Mr. Chair, that's correct, because, as I say, the opening hours are not a licensable activity of themselves, and the sale of coffee at 11 o'clock in the morning is not, or 8 o'clock in the morning even, is not a licensable activity either. And so on that basis, it doesn't actually trouble the licensing committee, because there's no licensable activity that's going on there.
I think the applicant will be grateful for that clarification.
Yeah.
Okay, where are we then on the agenda? We are supposed to ask questions, aren't we? If I go, Councillor Joy, do you want to start? Do you have any questions?
At the moment, I don't have any, thank you.
Sorry, Mr. Chairman, can I interrupt?
Yep.
Because I think, in actual fact, where we are in relation to the procedure, having got back on track, is there any questions at the minute? Would be questions of fact for me, and if there are no questions of fact for me, and obviously you've asked me some, in case any other, in fact, it's the members of the subcommittee rather than the applicant that has questions of fact for me, then that's the time for that is now. And then following that, then the applicant, rather than the applicant's witness, will then actually introduce the application and explain to the subcommittee what they are asking the subcommittee to determine.
Yeah, okay, let's do that. Over to you, Mr. Harris, then. Do you have any questions?
Is this where I come in and say I have no questions for Mr. Harris?
Yes, that's my understanding of what Mr. Harris just said. Yeah.
And neither do I, thank you.
Okay, so we are going now to Mr. We're going now to the applicant Sorry, Mr. Harris, can you help me?
Yep. So there were no further questions of fact for me, and so the applicant now is actually going to introduce their application, explain to the subcommittee what they are seeking, and so normally after doing that they'll have their witness evidence. But actually, in fact, we've already had the witness evidence. Although, if the applicant wanted to call their witness again to clarify anything that's been raised since then, because that was taken out of time, I don't really see there's a problem with that.
Okay, so what we really want to know from the applicant now is what they want to change from their current license, how it affects the hours. So that is Ms. Haynes. Do you want to do that?
I'm not sure I've got anything more to add than Charlotte's introduced in the first instance. As Robin stated, there have been a few emails going backwards and forwards with regards to a suggested compromise for some of the hours. But as far as we're aware, nothing has come back in terms of that. So I think we still remain as we were in terms of our original application.
Right. Yeah, I think the paper. We all read the papers. We all heard what Mr. Harris said. We heard what Ms. Hope said, and so it seems to be fairly clear to us, which confuses me with the procedure when things are so clear to us. Do my colleagues have any questions to the applicant, Councillor Joy?
Yeah, I just have one question. And you spoke about, there is quite a few objections that have come into us, whether they're valid or not. Could you just answer a simple question? Are any of the neighbours that are nearby you, any that actually use the club at any time? Thank you.
Shall I answer that one? Yes, out of those objectors, Mr. Newton, his family are members of the club, and as is Mr. Walker. Fiona Kitchen used to be, and we didn't part on particularly good terms. So the others, I don't believe are.
Thank you, that's helpful. Thank you.
Councillor Brindle?
I just have a couple of questions with regard to the showing of the films. You state you're going to have them outside. Could you explain how you intend to do that, and which direction the sound from any of the films shown will be projected?
I can answer that. I'd already actually spoken to the licensing office about this. I was asked the question as to whether we intended to show films outside, and my response, this was a couple of weeks ago now, was no, that wasn't our intention.
So when I'm looking at your application then, and you've ticked on item B, films, will the exhibition of films take place indoors or outdoors or both? You have ticked both. Is that now incorrect then?
I would suggest, turning to Charlotte here, I would suggest that it is not our intention to show films outside.
I think it's one of those things that we in our compromise table. I think it's one of the things we crossed off following the suggestion from Paul Newton that we compromise on something. It was sort of originally one of those things where people are showing these sort of outdoor cinema things now, where they turn up and it's a sort of one-off big event that we thought we would be able to accommodate at the club, but in theory, if it came down to it and we'd started to do one, then I suppose it would be under a temporary event notice if that's allowed. But it was just one of those things where we thought if we were going to apply for variations, we might as well apply for everything that we might possibly ever do.
I'm a bit confused now then, because you mentioned earlier that you wanted to go with the licence application as it stands now, which is the papers I'm looking at, rather than the compromise. So I'm a bit confused now as to what we're actually being asked to licence. Can perhaps Mr. Harris explain that to me?
Hi there. Yes, thank you, Councillor. I think, so there was, as I say, correspondence with the licensing officer who is, kind of acting as an intermediary between an objector and the committee of the club in correspondence. And obviously, what was said at the beginning of the meeting was that as they sort of, didn't believe they'd had any positive response for that back, that their starting position would be in respect of the original variation sought, which appears on page 1 of the agenda pack. However, obviously, having raised a point about indoors and outdoors, it's clear that actually the applicant is in fact willing to compromise on what has been asked for. And although I think this comes about in a slightly odd way, but I think if you look at page 47 of your agenda pack, that is the hours or the compromise that was suggested by the objector. And then on page 45 of the agenda papers, the response of the applicant is on there as what they're willing to do. So it might be actually helpful if everyone turns to page 45 of the agenda, looks at page 45, and perhaps then once we've gone through that, the applicant can then clarify if that actually would be the limit of what they are seeking. So on page 45, they're suggesting films indoors only from midday through until 2300 hours. I think it's worth mentioning that in relation to live music and recorded music indoors and outdoors, because the hours that are sought in respect of that are within the Live Music Act and within the Deregulation Act as well of 2015, that doesn't need to appear on the licence. Those are not actually licensable activities under law anymore. So the live and recorded music indoors and outdoors isn't a matter that needs to be considered, because the club can do that as a matter of law anyway. Which, as I say, only actually then leaves supply of alcohol on and off the premises is in fact as a variation, I think, unchanged. And then the opening hours, The only issue really is obviously they would seek to open at 0800 hours, which, as I say, doesn't actually attach once the changing of the films changes to midday. So there's no specific licensable activity that goes, that runs with that hour. So the opening hour as a non-licensable activity, isn't particularly engaged for the licensing committee to be concerned about, save for the applicant might like to clarify, almost as a matter of interest rather than a matter of necessity, that it's been raised repeatedly by an objector that this would be outside of their planning. So why they are doing something that would put them in breach of their planning. But again, it's not strictly a matter for the licensing subcommittee to determine, because it's a planning issue, not a licensing one.
So, sorry, Ms. Harris, with the music, you said the music is no longer licensable activity, then, playing music? The
only issue would be, and perhaps the applicant can confirm, if they would have an audience of more than 500 in relation to their music, then the exemptions that are provided by the Live Music Act, Deregulation Act 2015, wouldn't apply. But otherwise, the hours they are seeking, and in fact specifically between 0800 in the morning and 2300 in the evening, live or recorded music before an audience of less than 500 people is no longer a licensable activity as a matter of law. So it's not something that the subcommittee needs to consider.
So it wouldn't even allow me to sit here and question, well, your neighbours may be disturbed in the afternoon, what happened to you in their garden? So it's not relevant, is it?
It's not a matter for the subcommittee to consider on an application for variation. It could be considered if the premises were to be reviewed in the future, and the review was caused, for example, by public nuisance caused by music noise. Then under a review of the premises licence, then it would be possible to adjust those hours which are normally entitled to a premises as a matter of law.
So we'll bite my tongue on that. So we are really only looking at films. Whether the application as it stands is, it has been applied for being indoors and outdoors. So we have to look at whether we want to put some restrictions on that, and obviously the supply of alcohol. Okay, that's simple enough. I think I've got my answers here, and I don't really have any more questions to ask, except maybe I don't think Councillor Brindle was with us when the licensing committee once visited the Martin Club not too long ago. Even if you show films indoors or play loud music indoors, because you've got that big balcony at the top, there was some talk and some explanation about sounds carrying outside the building then into the neighborhood. Could you just elaborate on the actual physical implications of your building and how indoors music and indoors noise can carry to the outside? So we can't hear you. You may want to unmute your microphone.
Right. Okay. Yes. So obviously, I believe actually Councillor Joy, Councillor Brindle, and yourself all came to the club, because I think it was me that met you. No. Okay. So the club room is, we have got a wraparound balcony, and we've got sliding doors that open up towards the hockey pitches, and then others towards the cricket pitches. So yes, there is some carrying of sound. We have part of the planning application was to plant trees sort of all the way around the boundary of the site, but those trees are still quite immature, so they won't provide much of a barrier to noise at the moment. I have to say, on the objections, there were a couple. We had a couple of comments, I suppose it was really, during our Saints and Sinners charity match. So that wasn't actually a live music event, that was a sporting event, and because it was a fundraiser, it was a little more possibly lively than your average cricket match. In terms of playing recorded music and live music in the clubhouse, we obviously, if we don't want the noise to carry, we just shut the doors, and they are triple glazed, ball-proof doors. So in that event, you shut the doors and it keeps the noise in.
Great. Well, thank you very much. Are there any more questions from panel members?
Yes, I have one more. Could you just tell me how you communicate with those in the nearby village, neighbours, when you have an event? Is it online? Do you put up posters? I'm just curious as to, you know, sometimes you can be sitting in your house and then something suddenly happens, whereas if you're aware that something's happening, sometimes that can help. I just wondered what you think about, or what you have done in the past, just to cover the perception, really.
Well, in terms of the events this summer, the Saints and Sinners cricket match is actually a village event, and that was all over the village, so anybody could have come as our guests anyway. So that was almost a sort of, not an open event exactly, but so everybody would have been aware of that. I guess with the sort of more private events that we have, we probably only communicate it within the membership. So I mean, if communicating to the wider sort of neighbours and what have you would help, then that's certainly something that we could do to sort of smooth the path for it. I have to say they're incredibly rare. So our existing licence allows us to have 8 late events during the year, and since we were awarded that, we haven't used the 8. So these events are incredibly rare, which might make them a bit more of a shock, to be fair, to when they do happen, but they don't happen very often.
No, that's really helpful. The only reason I comment, I live right by Moat Park, and sometimes if I'm not aware and suddenly you're sitting in the garden and something happens, it can just be a bit daunting. So it's nice to be pre-warned. But thank you for your response. Thank you.
You just said about the 8 occasions extended. How long is the extension currently, and are you seeking on those 8 occasions a longer extension, or are we just carrying forward what you already have as a permit?
We haven't requested any more late licenses. I think we've got 8 a year, and I believe it goes to 1 a.m. Joe might have a bit more.
Supply of alcohol till 1.
Yeah.
And on a Friday until 2 o'clock on a Saturday.
Yeah. So
that is what you already got. You don't apply for that new.
Right.
Okay. Right. Yeah. And also you already have a permission for New Year's Eve. You just want to extend the mornings on New Year's Eve in line with your new opening hours. Is that correct?
Yeah.
Okay. Councillor Brindle, do you have any further questions?
No, thank you, not at this time.
Any questions from you, Mr. Harris? Some clarification?
Yeah, Mr. Chairman, if I may, I wonder if I could possibly ask, whether it be Mrs. Hope or Mrs. Hayes, just to clarify for me, in respect of the application then, if you can get page 45 of the agenda papers in front of you, the position you were suggesting in respect to films was for films 7 days a week, but from midday through to 2300 hours. Does that accurately reflect what you're asking the subcommittee to determine today?
I think that was the compromise we were willing to make. And again, I'll revert to Charlotte, but I think that's seems to be quite practical in terms of what we would be asking to do, really. I think we would be happy if that was our application.
Yeah, I think we originally sort of tried to line everything up so that the licensed activities fell into line with the opening hours. But as you've already pointed out, that doesn't have to happen. So if a compromise like that enables us to keep the neighbours happy, then I think we're happy to go with it.
Okay, thank you. And then just to be clear, in relation to the live and recorded music not being an issue on the licence, that is subject to it being of an audience of less than 500 people. Presumably that's what you'd expect on one of your on an ordinary days which this licence would apply, rather than one of your special events days, which obviously has music that goes beyond that timing anyway.
Yeah.
And therefore it is licensed separately anyway.
Yeah.
Because of that.
We haven't had any events of more than 500 people since our grand opening over 2 years ago, and we didn't have live music there anyway. So can I just ask a question on that? Does that mean that is the live music and recorded music going to be taken out of the licensing process, or will it stay in there? I mean, so when we make changes or ask for variation, why is it still in there if it doesn't really, if we can do what we're doing anyway without applying?
So in relation to obviously this particular variation, this variation is relevant from the point of view that you are adding a licensable activity which you didn't have previously, which is the showing of films.
Right.
And so it comes into that. And also, I think it was certainly, if there is perceived as being an increase in hours, and in fact, I think possibly there is an increase in hours, actually, if we go back to... in fact, yes, so actually there is, in relation to the supply of alcohol, on a Saturday, you'd be able to supply alcohol from 10 o'clock, whereas previously it was 11 o'clock. So whilst that is a relatively modest increase of 1 hour in the morning rather than in the evening, that is still an increase in hours, which can only be done by way of a full variation. Okay. In respect of the live music indoors and outdoors, potentially that, because that now is as a matter of law, is not something that you actually need on your licence, provided that it's between 8 in the morning and 2300 hours in the evening and it's before an audience of less than 500 people. That could have been dealt with by way of a minor variation to remove it from the licence, because it's a condition which is no longer relevant because the law has changed. But obviously, where you've got a variation that requires things to be changed by way of doing a full variation process, whether we can deal with it here. I think because of what you've confirmed today, that in relation to your ordinary running of the premises, the ordinary license, do you need that on your premises license? No, you don't. It can be removed, but it's helpful, I suppose, in relation to obviously we're not taking off the 8 occasions because you're not seeking to vary those 8 occasions, so they would stay the same. But yes, strictly speaking, you'd only not require a license in respect of points E and F on page 45, as long as the audience is less than 500 people. It seems it's likely that's going to be the case, and it's not something that needs to be licensed. And then obviously, then as I say, the opening hours, as I say, for the purposes of the subcommittee, it kind of depends on to what extent it is attached to a licensable activity. In respect of this, the opening hours in the evening, obviously, films, for example, which is a licensable activity, is going to terminate at a particular hour. But I don't think other than that, it's particularly an issue. Obviously, then there is no licensable activity that's going on earlier than 10 o'clock in the morning, and only then on a Saturday. So from that point of view, if you open at a different time, to an extent, it's neither here nor there. Except, of course, that if you were to only open at 11 o'clock in the morning, your theoretical supply of alcohol at 10 would be impossible because you wouldn't be open. So you'd
Right.
expect it to be at least 10 o'clock in the morning as an opening hour, because that's the earliest time that a licensable activity will take place.
Mhm.
But I've got one final question for you, which is that, again, it has been noted quite specifically by at least one objector about that would be in breach of your planning. Again, whilst that's not a licensing issue per se,
Mm.
might be helpful to understand why you're seeking licensing hours that are different to your planning hours.
Yeah. Well, I think there's been a little bit of misunderstanding from us, because we thought that opening hours was part of the license. But really, though, the issues with the earlier opening have come about because our groundsman goes in during the summer at the crack of dawn to prepare a cricket pitch. So obviously Mr. Newton has raised that planning restriction, and it's really because of that. And we have sort of, cleaners going in early and deliveries coming in early. So I think as the opening hours, as you say, unless they're attached to a licensed activity, that would almost be a discussion between us and the neighbours, as to whether they were comfortable with that happening. I mean, we don't have parties at 8 o'clock in the morning. We have groundsmen going in, we have cleaners going in, we have deliveries coming in, the bins get emptied and that sort of stuff. So that planning restriction, which we do intend to address, we believe was more intended for during the construction of the site, in that they didn't want the neighbours disturbed by bulldozers at 6 o'clock in the morning. So we were aware of the sort of anomaly between planning and licensing, but strictly speaking, we don't need a license to open at 8, I think is what you're saying.
You don't actually have any licensable activity happening before 10 o'clock in the morning in respect of your license.
Okay. So the cleaner and the groundsman going in at 8 a.m. is actually really only a planning issue.
It's not a licensable activity.
Right. Okay.
Even with a planning issue, I don't know your actual planning permit, but it's not opening when the cleaner and the groundsman goes in. Opening hours are hours available to the public or to your members.
To the members, right? Okay.
That would be my interpretation, but then we would have to study your, or you would have to study your planning.
Yeah. Okay, that's fine.
The only issue is here with your application. Obviously, you are asking for films to start at 8 o'clock in the morning, which is
The compromise is now midday. I think.
midday.
Yeah.
Okay. So midday till 2300 hours. That's what you're
Yeah,
asking.
we'll be happy with that.
And we're removing the five items a year. Is that part of the compromise? I'm looking at page 45.
So no, the 5 events per year was suggested by the objector in relation to the showing of films, but the applicant wasn't willing to accept that as a compromise. So the applicants crossed that through.
Okay, so just to confirm then, we're looking at films operating between midday and 11 o'clock at night, Monday to Sunday. We're looking at live music indoors and outdoors. That's not part of what we're being asked to look at for the license because the law has changed. The same with recorded music, and the rest are the opening hours at 8 o'clock so people can have a coffee, but no sale of alcohol.
Neither that is our remit. The only thing is the change of the Saturday alcohol license to bring it forward from 11 o'clock to 10 o'clock.
Right, thank you very much.
Right. Yeah. Makes sense. Mr. Harris, would it be sensible for us to invite the applicant to take the music, to have that removed from their license, or would it be just as good just to keep it in the license?
Now that it's been confirmed that the music, live and recorded music indoors and outdoors, falls within the exemptions that exist within the law, then we could remove those from the license in respect of items E and F on page 45, whilst obviously leaving the other occasions, which are event occasions, on the license, because they would want that.
Would the applicant have to ask us to do that, or can we do that simply as a matter of clarity of procedure?
Bearing in mind that the application for variation is before you, and it is clear that those licensing conditions are no longer required, I think you could take the step that you removed them. Equally, if you were to leave them on the license, of course, it would mean that it was there, and they would not be bound by the requirements of the law. For example, in respect of less than 500 people, it would be on their license as a matter of right, as their own licensable activity. Although, as it seems relatively unlikely that they're going to actually require that to be on the license. It's whether they would find it more helpful to have it removed from the license entirely, or whether they would like to have it on the license because it gives them the flexibility of having more people.
Well, Mrs.
Well, I can't foresee a time when we'd have more than 500 people, but so the 8 occasions a year that we have, which are obviously for extended hours, would that permit us to have more than 5? If we used one of those extra licenses for an event of more than 500 people, does that work?
It would work after 6 o'clock in the evening.
Okay.
Because obviously that only kicks in at 6 o'clock in the evening, whereas otherwise you would have less than 500 from 8 in the morning till 11 in the evening. But on those Friday and Saturday occasions, or New Year's Eve, because it was on your license as a matter of right, you wouldn't be bound by those numbers, which was created by the exemption which exists in law.
Okay. So, Joe, I have to ask Joe, I mean, the chances of having more than 500 people are pretty minuscule, I would say. Having them on the license does sort of confuse things for us. So it would make sense, I think, to have just take them off and work with the exemptions. The legal exemptions.
Yeah, I agree. I think if it's not relevant, I think let's take it off. Yeah.
Is that okay?
Mr. Harris, if the applicant has a daytime event of over 500 people, they would always be free to apply for a single event license.
Yeah.
A temporary event notice wouldn't assist them in that occasion, because a temporary event notice is only for up to 499 people, including staff. So if they want more than 500 people, it needs to be on their license.
Okay.
A 10 won't assist them. Although, I mean, getting clever, of course, you can have 2 temporary event notices for the same premises in different areas, and therefore you could have 1,000 people under 2 tens, as long as you made sure there was never more than 499 person in each area. That's getting into the dark arts. Probably shouldn't.
Sorry, could I ask?
Who's going to enforce that?
Sorry, could I ask if when we're referring to the premises, so there's no way we'd ever fit 500 people into our clubhouse, and that is one huge marquee also. So when we're referring to premises, are we referring to the building itself, or, you know, for instance, if you had 500 people during the day, they would have to be, for instance, around the cricket ground, I would say, on the cricket ground. So how does the rest of the site fall under the licensing application?
So the question, which would then determines the answer, is your licensed premises purely the clubhouse, normally identified on the plan you originally submitted with your license application by a red line around the area you want licensed, or is your licensed premises the entire ground?
My understanding, because this has been clarified already by the licensing office, is it's just the clubhouse.
So in which case, the licensed area is the clubhouse, and the grounds are not licensed, which means when people, I'm sure you have a license for on and off sales.
Yeah.
And so people who depart to parts of the ground to watch sport with a drink are doing so because they have made an off sale and they have purchased the alcohol under the off sale license and have then taken it off the premises, which is the clubhouse, and into the grounds, and it's being consumed off the premises as an off sale.
Okay, so in that case, we have no need for for more than 500 people, because we would never fit 500 people into our clubhouse.
Yeah.
So we have a maximum of, I don't know, 120-ish standing or something like that. So so that must well come off.
Okay, thank you.
Right.
Sorry.
It was getting more complicated than what I expected it to be this morning. Right. Do we have any more questions, any more points to raise, members? Councillor Joy, Councillor Brindle?
No, thank you.
No,
thanks.
Mr. Harris, you are clear now about everything?
I am indeed. Thank you very much, Mr. Chairman.
I am as clear as I can be as well. I think it is the chance now for the applicant to make a final closing statement.
Joe?
Charlotte?
I'm quite happy just to say that contrary to some of the objectors' comments, we aren't trying to turn into an events venue. We're not trying to turn into a cinema. We're simply trying to accommodate the growth in the sport that we've provided and that our members are all obviously so keen to access. And we were just trying to realign our licensing with what we've been led to believe the members are going to be wanting over the next few years at least. So there isn't any attempt to become some sort of huge events venue, and we've managed it very well under the current restrictions, but we just feel it's time to realign everything.
Thank you. I think we none of us has any further questions. Everybody, you said what you needed to say, so I can now declare this hearing closed, and the subcommittee, accompanied by the legal advisor only, will now enter into a closed session to deliberate. All those that have dialed into the meeting may wait on the call for the subcommittee members and officers to return. Following a decision, the subcommittee will rejoin the public Skype meeting. Mr. Harris, do we have any idea how long probably we'll need for deliberations?
I wonder if we were to suggest that people can step away from the call until at least 11:30, and then we can come back at 11:30 and either give an update on where we're at in relation to giving a decision, or giving a decision if one's been made in that time.
I think that sounds a reasonable idea.
Okay.
So we meet back at 11:30 here.
Yep.
So can somebody just tell me how I do this? How do I just go back to the same meeting?
Yeah.
Right, okay,
Yes.
perfect. All right. Okay,
That's
thank
correct,
you
Ms. Parfitt, isn't it? That's
That is
where we
indeed,
go.
Chairman, yes.
then. Okay.
And we should have a link to join another meeting, shouldn't we, somewhere in our diary? I would now like to announce the committee's decision. We agreed to indoor film showing from lunchtime 12 o'clock till 2300 hours. We will also remove the live and recorded music conditions as they are superseded by statutory permission. We will extend the licensing hours for supply of alcohol from 11 a.m. to 10 a.m. on Saturday mornings. And we agreed to opening hours as applied for, subject to an advisory that these hours are not compliant with planning, may not be compliant with your planning permission. And finally, we recommend that the club engages with their neighbours when the 8 occasional extended hours options are utilised. All parties to the hearing will receive a copy of the written determination notice regarding the subcommittee's determination. All parties may appeal against the subcommittee's decision within 21 days, beginning with the day on which the appellant is notified of the decision. I think the last, here's the last paper. Licensing authorities' written determination. Appeals must be lodged with the Magistrates' Court. Parties should be aware that the Magistrates' Court may make an order with respect to the costs of any appeal. The appeal hearing is now formally closed. Thank you very much for attending.
Thank you.
Thank you.
Right, everybody, have a good weekend. And
Okay. Will do.
I'll see you guys soon, I suppose.
Thank you very much.
Thank you.
Bye.
All right.
Thank you, Mr. Chairman. Goodbye, all.
Bye.